Committee will come to order. When a crisis unfolds, our government needs to be able to respond quickly, whether it's a pandemic, extreme weather, or a foreign attack. We must be ready to protect the safety and the security of our citizens. In order to act quickly when disasters strike, Congress has given the President broad emergency powers. Most emergency powers have never been used, but they could potentially bring sweeping changes to our government, to our economy, and society. These powers could allow the government to take over communication channels, control transportation systems, halt trade with other countries, and more. Without an appropriate check from Congress, there is a risk that these powers could be misused or abused. And that's why Congress passed the National Emergencies Act in 1976. This legislation gave Congress the power to conduct oversight over these powers, including a mechanism to quickly end a national emergency. But after a 1983 Supreme Court decision, the National Emergencies Act had to be amended, and the mechanism for Congress to end a national emergency was weakened. It now requires a veto-proof two-thirds majority in both chambers of Congress. In other words, there is an imbalance of power. It is easy for a president to declare a national emergency, but very hard for Congress to end one. We've seen presidents of both parties increasingly use emergency powers. In cases like the COVID-19 pandemic, this was necessary to protect our economy and public health. In other cases, recent presidents have used emergency powers to attempt to advance their policy goals, often in areas where Congress should be providing input as well as oversight. Reforming the National Emergencies Act is not about thwarting the policy goals of either party. It's about strengthening our democracy and ensuring Congress maintains the responsibility to oversee executive power. We have had bipartisan support for this reform in the past, and I'm hopeful that we can build on that progress, and I'm looking forward to considering legislative options that can advance this in committee this Congress. We must examine how we use our current national emergency power authorities and ensure that Congress can effectively oversee emergencies. Today's hearing and our panel of expert witnesses will help us do that, and I look forward to the discussion. Now I recognize Ranking Member Paul for his opening remarks.
In 1867, a journalist named Walter Bagehot explained that in Britain, the monarchy and the House of Lords no longer exercised true governing authority, that the real work, the real power of government was done by the House of Commons and the Prime Minister. In contrast, the United States has allowed the majority of governing power to remain in the executive branch. In some ways, the United States of America is a monarchy in disguise. The United States maintains the veneer of a constitutional republic, but often operates as an elected monarchy in which the president exercises awesome and unchecked power by decree. Today, the president can unilaterally determine when and how to unlock and exercise extraordinary powers not permitted during normal operations. Once the president simply declares an emergency, emergencies are rarely terminated. The national emergency declared in reaction to the 1979 Iranian hostage crisis is still in effect to this day. Some powers are so inimical to the concept of constitutional republic that they could never have been granted to the president or should have never been granted to the president in the first place. One such emergency power, pursuant to the Communications Act of 1934, gives the president nearly unchallenged authority to restrict access to the internet, conduct email surveillance, and control computer systems, television and radio broadcasts, and cell phones. President Woodrow Wilson actually used a similar power 3 times during World War I. These laws were written for a different time, but this power, which some refer to as the Internet kill switch, threatens the rights protected by the First and Fourth Amendments, as well as property rights, simply by declaring an emergency. This dangerous imbalance of constitutional separations of powers is not simply aggrandizement by the executive branch. Congress has been complicit and made itself a feckless branch of the federal government by granting the president so many emergency powers and refusing to regularly vote on termination of national emergencies as required by current law. We do not have to accept as inevitability the degeneration of a republic into a rule by an all-powerful executive. We do not have to be a monarchy disguised as a republic. It's time for Congress to restore itself as the first among equals of the branches of government as envisioned in the Constitution. I hope this hearing marks only the beginning of a serious and sustained effort to restore the Constitution, reclaim the authority of Congress, and protect the liberties of the people by paring back the vast emergency powers delegated to the President.
It's the practice of this committee to swear in witnesses, so if each of you will please stand and raise your right hand. Do you swear the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Our first witness is Elizabeth Gotin, and she is the Senior Director of the Liberty and National Security Program at the Brennan Center for Justice. Prior to that role, she served as counsel to Senator Russ Feingold and as a trial attorney in the Federal Programs branch of the Civil Division of the Department of Justice. Ms. Gotin is a nationally recognized expert on presidential emergency powers, government surveillance, and government secrecy. Ms. Gotin, thank you for being before us here today. You are recognized for your opening comments.
Thank you. Chairman Peters, Ranking Member Paul, and members of the committee, thank you for this opportunity to testify. The legal framework for emergency powers in this country is in urgent need of reform. It grants the president sweeping powers, some of which seem like the stuff of autocratic regimes, with few safeguards against abuse. Fortunately, there's a ready way for Congress to build a meaningful check into this system. Emergency powers have existed in countries around the world for hundreds of years. The theory behind them is simple. Because emergencies are, by definition, unforeseen and unforeseeable, the powers conferred on the government by existing laws might be insufficient to address them. But amending the law to provide greater powers might take too long and might do damage to principles that are held sacrosanct in ordinary times. Emergency powers thus authorize a limited departure from the legal norm. Their purpose is to give the head of state a temporary boost in power until the emergency passes or until there's time to change the law through the normal political process. Many countries have emergency powers written into their constitutions. The US Constitution is an outlier. It grants no explicit emergency powers to the president. So presidents have, for the most part, relied on Congress to provide them. About a century ago, a system evolved where presidents would declare a national emergency, and that declaration would trigger special powers contained in a whole range of statutes, all of which said something like, in a national emergency, the president can do X. But there was no overarching statute governing this system. The president didn't have to identify the powers he was invoking, he didn't have to report to Congress, and there was no limit on how long emergency declarations could remain in place. Congress passed the National Emergencies Act in 1976 to rein in presidential power. It attempted to do that in three main ways. First, it provided that emergency declarations would expire after a year unless the president renewed them. Second, it allowed Congress to terminate emergency declarations using a legislative veto, a law that goes into effect without the president's signature. And third, it required Congress to meet every 6 months while an emergency declaration was in effect to consider a vote on termination. By any measure, the National Emergencies Act has failed to achieve its purpose. Expiration of emergency declarations after 1 year, which was supposed to be the default, has become the rare exception. There are 43 emergency declarations in place today, most of which have been in effect for over a decade. In 1983, the Supreme Court held that legislative vetoes are unconstitutional, so now Congress effectively needs a supermajority to terminate a declaration over the president's likely veto. And for more than 40 years, Congress simply ignored the requirement to periodically review existing emergencies. Why should this worry us? Because an emergency declaration unlocks powers contained in more than 130 statutory provisions, and some of these carry enormous potential for abuse. There is a law that allows the president to take over and shut down wire or radio communications facilities. It was last invoked during World War II when wire communications meant telephone calls or telegrams, and most American households didn't even own a telephone. Today, it could arguably be used to exert control over US-based internet traffic. Other laws allow the president to freeze Americans' assets without any judicial process, to control domestic transportation, and even to suspend the prohibition on government testing of chemical and biological agents on unwitting human subjects. Given how potent these powers are, it's remarkable that there hasn't been more abuse. We've been lucky, but it would be irresponsible to continue to rely on luck or presidential self-restraint. Congress should pass legislation to restore its role as a check on these powers. There are several bills pending before Congress right now, broadly supported by Democrats and Republicans, that would require emergency declarations to terminate after 30 days unless approved by Congress using expedited procedures. This simple, common sense change would give presidents flexibility when it's most needed in the immediate aftermath of a crisis, while still allowing Congress to step in and serve as a backdrop against executive overreach or abuse. Thank you, and I look forward to your questions.
Well, thank you. Our second witness is Satya Thullum. He is a senior fellow at the Foundation for American Innovation. Mr. Thullum is a policy expert and an advisor on administrative law, regulatory policy, and emergency powers. Previously, he was a senior policy official at the Office of Information and Regulatory Affairs under President Trump. He also served as the chief economist on the Senate Homeland Security and Government Affairs Committee. I'm familiar with that committee and serving under Chairman Johnson. Welcome back to HISGAC. You may proceed with your opening comments, Mr. Thullum.
Thank you, Chairman Peters, Ranking Member Paul, and members of the committee. Thanks for your invitation to testify and return to a place I consider a second home. My name is Satya Thullum. You have my bio, but as was mentioned, I think is most pertinent, I was for 5 years a senior staffer at this very committee, where the final bill that I managed was a proposed reform to the National Emergencies Act. I did that before I left, which was alluded to in your opening statement, was reported favorably by voice vote at the time. I'll forgo restating much of what has been and will be said by my esteemed colleagues, especially since I could probably just copy and paste the chair and ranking member's opening statements and just enter that into the record because I agree with all of it, but I'll remark on a couple comments. First, the National Emergencies Act is a thoughtful solution to a problem of Congress's own making. Like many things in both executive and congressional practice, sometimes one-time circumstances prompted one-time responses. But over time, those policy responses build up without any systemic consideration of their total effect. Indeed, powers meant to be exercised only in the case of an emergency have been observed since before the country's founding. The Federalist Papers speaks of powers needed to address, quote, national exigencies. In 1776, General Washington observed, desperate diseases require desperate remedies, when the Continental Congress, needing to flee Philadelphia, empowered him with, quote, full power to order and direct all things relative to operations of the war. Of course, the word emergency does not appear anywhere in the Constitution, and yet Congress, as the sole lawmaking branch, has deemed it necessary to grant emergency powers across hundreds of duly enacted statutes. The conceit being that the executive, in execution of the law in the public interest, will need to respond to uniquely emergency situations, though that delegation should be cabined by congressional say-so. So I would note, although the NEA is definitely in need of an update, owing to an unforeseen judicial decision, its basic structure is sound and is appropriate for Congress to re-examine it to better assert its Article I prerogative. Second, a conceptual note, if you'll bear a slightly tortured metaphor. Think of the National Emergency Act not as the direct grant of emergency power itself, but as a key which unlocks a vault in which is enclosed the actual instruments of emergency response. That is, Congress, when it authorizes through other statutes emergency powers, adds to the tools in the vault. The problem is that there's no timer on this vault, nor easy, plausible way to take back the key. Another central conceit, emergencies are by definition unpredictable, but they should also by definition be time-limited and self-evident. Therefore, Congress doesn't need to run down the impossible task of prescribing every possible emergency, but rather ensure it has the means to have its say with respect to emergency declarations and the attendant emergency powers based on those generalized aspects. However the committee decides to proceed, the sweet spot for any reform is one that is on its face policy neutral and designed to service only the interests of Congress's lawmaking role vis-a-vis the president, rather than any particular political agenda. Thank you, and I look forward to your questions.
Thank you. Our third witness is Gene Healey. He is the Senior Vice President for Policy at the Cato Institute. His research interests include executive power and the role of the presidency, as well as federalism and over-criminalization. Mr. Healey, welcome to the committee. You may proceed with your opening remarks.
Chairman Peters, Ranking Member Paul, distinguished members of the committee, thank you for the opportunity to testify today. As my fellow witness, Ms. Gotin, mentioned, upon assuming office, the president now enjoys access to over 230 statutory powers that he can activate in a self-declared national emergency. Most of them can be triggered simply by saying the magic words and putting a signature on an emergency declaration. My other co-panelist, Mr. Thullum, suggests that we think of these powers as tools contained in a vault. And I like that metaphor, but in some cases, for tools, I'd substitute weapons. The original National Emergency Act was an attempt to as he says, to safeguard that vault and time limit the president's access to the weapons that it holds. But when the NEA framework collapsed in the mid-1980s, the vault door swung open. And since then, the only thing keeping presidents from raiding the arsenal is their sense of self-restraint. So in that light, it really is remarkable that we haven't seen far greater abuses. Despite the lack of meaningful legal checks on these powers, up until now, according to the Brennan Center's research, nearly 70% of these powers have never been triggered, at least not yet. But over the last two administrations, we've seen that whatever norms once restricted the use of presidential emergency power have eroded. For instance, in decades past, no president seems to have imagined that you could tap into that arsenal to do an end run around Congress in a budget fight. But that's precisely what President Trump did in February 2019 when he declared a national emergency in order to build the wall on the southern border. Nor does it seem that any prior president imagined he could invoke emergency powers to permanently cancel hundreds of billions of dollars in student loan debt without authorization from Congress. But that's what President Biden attempted with another emergency proclamation in August of 22. As my colleagues have suggested, the way to re-secure the emergency powers vault is pretty straightforward. It involves amending the National Emergencies Act to impose an approve or expire framework, sunsetting presidential emergency declarations after a matter of weeks and requiring actual authorization from Congress to extend them further. Those process reforms are essential, but I'd like to suggest that the committee consider substantive reforms as well. In addition to thinking about how to safeguard the vault, taking a look at the arsenal that's within it. If there are weapons in that vault that the president doesn't need, weapons that are especially susceptible to abuse, consider taking them off the shelves. For instance, any comprehensive effort at emergency powers reform will ultimately have to deal with the International Emergency Economic Powers Act, or IEPA, at some point. That 1977 law has been the source of nearly 90% of emergency declarations historically and over 90% of the ones still in effect today. And while most of these have been fairly uncontroversial, they're not actually emergencies, the vast powers that IEPA grants are particularly susceptible to abuse. For instance, in the months after he declared the border wall emergency, President Trump twice threatened to weaponize the statute against major U.S. trading partners, first against Mexico with a series of across-the-board tariffs that would go into effect unless they cracked down on cross-border migration. And shortly after that, the president cited the statute as authority for hereby ordering American companies to get out of China. Thankfully, the president didn't follow through on those threats, but if a future president does, it's not at all clear that the courts will stop that action. Even more concerning, nothing in the statute prevents it from being turned against American citizens. Such uses have been rare, but they're potentially available. Substantive reforms in these areas could include barring IEPA's use as a trade war weapon, restricting its use to directly target Americans, as well as shoring up due process protections for any U.S. person caught up in the statute sweep. In conclusion, any of these reforms would provide a better check on abuse of power than depending on presidential self-restraint. It should be clear by now that that's far too weak a check. I thank the committee for its attention to this important issue, and I look forward to your questions.
Well, thank you. Mr. Thullum, most reform efforts to the National Emergency Act propose that Congress affirmatively approve each national emergency. So my question for you is, what is the value of having Congress approve rather than disapprove each emergency? And Mr. Healey, I want you to weigh in on this too, please. Mr. Thullum.
Well, I think I would slightly modify that in the first instance, most of the proposals do not require Congress to approve, but for a certain time limit. So after a certain period, so 30, 60 days, it would require Congress to approve any extension of that. And in the failure of Congress to decide to extend it, it would be ended by default. So I think, again, the original NEA had a disapproval mechanism that got around the presidential veto, but of course they didn't, I don't believe the authors anticipated a court decision that would invalidate that structure. I think the original authors of the National Emergencies Act, if they were addressing this issue now, would do what is in many of the recent proposals, which is by default, Congress has to assert its approval or the emergency ends by default. I think disapproving is just a much higher barrier, and that it's what we result in now.
Ms. Gotin, I'm going to want you to weigh in too, but Mr. Healey?
Yes, I think that's right. I think the frameworks for emergency powers reform that we see now reflect the Chadha decision, getting rid of the legislative veto. And, all of them, the Protecting Our Democracy Act, Article 1 Act, the other bills that have been proposed, are based on an approve or expire framework in which the president will have 30 days in the case of a genuine national emergency to unlock these powers. But if the emergency persists and these powers are thought to be necessary, this weapon is supposed to remain available, then Congress has to vote. So I think they all are, the shape of the statutes we see are a reflection of what the Supreme Court did in Chadha, and a way to, given that decision, to reassert Congress's authority over these matters, rather than what has happened since 1985 with the removal of the legislative veto. We're really in an upside-down constitutional situation where the president proposes and essentially the president disposes, and it takes a veto-proof supermajority for Congress to reassert its authority. And these are designed to turn the Constitution, to turn the emergency powers practice right side up.
Very good. Ms. Gotin.
I agree with what's been said. It's important to remember also that a national emergency declaration gives the president access to truly extraordinary powers and to a degree of flexibility and discretion that would not be appropriate during ordinary times and that Congress hasn't chosen to give the president during ordinary times. And for that reason, Congress wanted to make it easy to exercise some restraint on the president if the president abused those extraordinary powers. And that's why Congress chose the legislative veto mechanism. Now that that's off the table, the existing mechanisms for disapproval require such a high bar that they stack the deck very much in favor of the president and against Congress. It throws the balance of power out of whack. The closest way to approximate the balance of power in the original National Emergencies Act is the mechanism that's been proposed in these reform bills, which is an expiration, an automatic expiration period of approximately 30 days. I think in some cases it's 20, depending on the bill, unless Congress votes using expedited procedures, which means that it would be a simple majority vote where any member could force a vote. This would prevent obstructionism. Congress would be voting, and a simple majority would carry the day. But it would put Congress back in the position of being able to exercise a check on these extraordinary powers.
Very good. It's important for these reforms to be nonpartisan, to understand that we're talking about executive power regardless of who is in that office and what party they may be from. We have three experts, three of you here before us here today, and I would just like to get a sense, and all of this is up to all of you, so anyone who wants to chime in. Do you believe that there's a bipartisan consensus among experts, among policy experts, as to how we reform the National Emergency Act, and how would you characterize that right now? Whoever wants to go first.
I mean, this is self-selecting among the experts I've spoken to. There's widespread agreement. I think the folks who have written and studied this issue agree with this central conclusion that the NEA, as structurally intended, was fairly thoughtful, but for an unforeseen judicial decision, it rendered it fairly inert. And so the best way to address that is with a reform that creates this, that inverts the structure. I'd also note it's helpful to think of these reforms as not just purely oppositional, the Congress versus the executive, but it provides and in fact forces Congress to take a stand on emergency declarations. If it truly is an emergency that's self-evident, that's maybe existential in nature, then it should be possible for the president to gather the political support to extend that emergency and that response. So it actually provides an Article I imprimatur on any emergency declaration. And regardless of how Congress disposes, it forces Congress to have to step up and say, I'm taking a stand on this, whether it's yes or no to continue it.
Anyone like to add to that? Ms. Gotin?
I would agree with that. And of all the issues I've worked on in, I guess almost 20 years at this point of doing this type of work, this issue probably has the broadest and deepest bipartisan support, not just among policy experts, but among members of Congress who I've spoken with. And there is a fundamental understanding that this is not a partisan issue, but an issue of separation of powers, and that the separation of powers is not an optional feature of the Constitution that can be switched on or off depending on who is in the White House. It is a vital protection for our democracy. And emergency powers can be abused and have been abused by presidents of both parties. So this is fundamentally not a partisan issue. It's an issue of safeguarding individual liberties, of safeguarding our democracy, and I think that's well understood.
We're over time, but Mr. Healey, you have a quick response?
I don't have much to add to what my co-panelists have said. Yes, I think this is both within the policy community, such as it is, and on Capitol Hill, this is an issue that gets a lot of bipartisan support because it really, we should take a longer time horizon and recognize that at any given point, somebody may like what a president does with a vast delegation of unilateral powers, But, this, over time, it erodes separation of powers and the rule of law. And I think we've seen that in the last two administrations, and we've seen bipartisan support for reforming it.
Right, thank you. Ranking Member Paul, you're recognized for your questions.
I don't think it has to be partisan at all. Example that somebody who once worked for Russ Feingold is in complete agreement with somebody who is from the other party and an opposite wing of the other party, that there's definitely overlap. I think there's overlap between the chairman and I on this issue. I think when you watch this unfold, you tend to see Republicans louder when Biden abuses of power and Democrats louder when Trump abuses of power. But I can say that when Trump moved the money around using emergency powers for the wall, I was one of the 12 Republicans who voted to rein in that power and that it wasn't appropriate use, it was abuse of power. I think as far as an adversarial relationship, there needs to be some. It needs to be the legislature against the executive like the good old days when we could combine Republicans and Democrats to always say, we are going to do, as Madison said, pit our ambition against their ambition, and those checks in power would be the way the republic would remain protected. We don't do that enough. I can't remember when. It's been decades since the legislature rose up and said enough's enough. We did a little bit in the 1970s. The Church Commission was a reaction to too much executive power and too much power within the intelligence agencies. But I can tell you how bad it is right now. I'm trying to get the classified Church Commission report from the 70s and can't get it. So the administration, the executive, but how is the only way I could get it? Somebody on appropriations would have to call up the current administration and say, give it to them or we're not giving you any more money. That's the way it would work, and it shouldn't matter which party we're in. But I can't get the classified Church Commission report from the 1970s, which I think came out of this committee or what committee?
Special committee.
It was a special committee, but I mean, it's like, it was a Senate product, and I can't get it. So, I mean, it's just kind of crazy, the resistance of the executive branch. I think everybody here understands how things got turned over topsy-turvy by Chadha, but I think it's important explaining to the public what we mean by that. The legislative veto would mean you could just come back in and the legislature could veto an emergency power or end it. And then the president didn't have to sign it. The court came back and said, no, you can't have any laws. And there's some logic to this. You can't have a law unless the president signs it. So the only way we gain our power is we have to let things expire. So the emergency powers have to expire. And this is getting to my question. Most of the emergency powers, I think as researched by the Brennan Center and as mentioned by Mr. Healey as well, are under IEPA. So previously we tried to do this and then we say, oh gosh, but we love sanctions. Everybody loves sanctions. We don't want to do anything to have sanctions expire. But if you exclude IEPA, you exclude like 90% of the emergency powers. And so the real question shouldn't be, do you love sanctions or do you have doubts about sanctions? Do you think sanctions should be forever and Congress should never weigh in? Maybe if you love sanctions, we should still vote on them. And they should expire and come back here in 6 months or a year and we vote on them. And if you love them, I think the majority of people probably, I'm in the minority, the majority will probably still vote for sanctions on everybody all the time, everywhere. But there would at least be a debate and we'd put our imprimatur on it. And then by putting our imprimatur on it, if you love sanctions, actually the sanctions may be stronger because they're not actually approved by Congress. But right now we have no say in it and they go on. And most of the emergency powers, there's really dangerous ones, internet kill switch and things, but there's also ones that are used all the time, which are sanctions, increasingly used on private individuals in other countries, sometimes used in Americans in other countries. So I guess my question to all three of you, and we'll start with Mr. Healey, is do you think the reform that time limits emergency decrees and says that they have to be affirmatively voted on by Congress should apply to IEPA emergencies?
I think ultimately it should be under an approve or expire framework. Now, I think there's reasonable debate that can be had about, time limits and particular provisions or whether it should all be part of the same bill. But I think if you were looking down a list of extraordinary emergency powers, such as the Brennan Center has produced, it first came out in 2018 before the last two controversial uses of emergency powers. If you were looking down that list, you wouldn't have singled out the Military Construction Codification Act that was the basis of the border wall emergency, or the HEROES Act that was the basis of the the student loan debt cancellation. I don't think they'd be anywhere near the top of your list of broad, crazy delegations of power. I think looking behind a veil of ignorance, looking at that list, you would identify IEPA as something that can be turned against U.S. persons and something that can essentially make people financial untouchables, and you'd be concerned about that.
I think you're right, and I just wanted to interject that during the middle of COVID, they took a CDC statute from the 1930s that said you can quarantine people for measles and like 10 other diseases and whatever other measures are necessary. And through that, the Trump administration canceled mortgages and said you don't have to pay your mortgages. Then the Biden administration did the same thing. So both parties were guilty of this, but they took a statute that had nothing to do with mortgages, and no sane person could think that a quarantine on measles has anything to do with paying your mortgage, and they abused that power. But that should be, whether you like people paying their mortgages or not, or like the rule of law, everybody should say that's illegal and unconstitutional. We shouldn't let executives do that, but we don't. We tend to base it on the policy. Do we like the policy or we don't like the policy, instead of should the president be able to do this unilaterally on a statute that never gave him this? Ms. Goitins, on including IEPA?
I think IEPA raises unique considerations and should be addressed separately. I think the National Emergencies Act reform bills that are currently pending both go too far and not far enough in certain ways. I think that requiring Congress to vote 40 times every year on sanctions regimes, which is what would happen if you applied the NEA reform bills to IEPA declarations, would be impracticable and possibly unnecessary. And so I think a modified...
They possibly could be grouped as well.
I think
mean,
that's
if you have
right.
an emergency against Russia and there are 40 different sanctions against Russia, I don't think there's anything that says that we couldn't come forward and vote on the emergency that includes 40 different sanctions, not each individual sanction.
I think you would need to structure a system where there could be a vote on with expedited procedures on a package of sanctions once every year with amendments in order to strip individual sanctions regimes. I think that's
But it once again only works if they expire.
That's correct, but that's a slightly different framework than what's in the bills that are currently pending before Congress. And I would add that this approval requirement would not solve some of the other problems with IEPA, such as the absence of due process protections for Americans who are swept up in its crosshairs, such as the humanitarian impacts on innocent foreign populations overseas. So
I agree with all that. The only problem with separating it is Congress is, as I said in my opening, often feckless, if not most of the time. So if we ever do anything on NEA, it'll be a miracle if we actually pass it through and get it completely done. But I would say that if we leave out IEPA, we're leaving out an opportunity when what we're talking about is emergencies, and people are going to say, oh, you got rid of 4 emergencies out of 79 or something. You know, we're going to get rid of the minority, we're going to fix a minority of the problem. So if anything, I'd argue for doing it all at one time. Mr. Thullum?
I mean, so to answer your question, should it be addressed? Yes, and I agree that I think there are 2 concerns there, not with the intent. One is structurally how those emergency powers tend to work in practice. The second is prudential. And putting on my staffer hat, I remember negotiating about how much to include of IEPA and whether or not to. Look, as a principle, I think you're right. I just caution the committee that you have a reform or a version of reform that is within grasp and that could pass Congress and could get to the president's desk. Wholesale, including IEPA, just increases the complexity, which doesn't mean don't go for it, but it just becomes that much more slippery. And it's like trying to pick up antimatter with chopsticks or something. Like the number of committees that get involved and like the Treasury Department, it just becomes, don't let the perfect be the enemy of the good is my only thing I would add, even though I agree with the intent.
Could I add one thing to that, just briefly? I think you're only going to get one bite at the IEPA apple. Take the time to do it right. Don't throw some provisions about IEPA into the national emergencies reform bills that exist right now. Those bills are ready to go. Get them signed and take the time to do an IEPA reform bill. The Biden Center has a proposal for legislative reform of IEPA. I would be happy to work with anyone on this committee who would like to examine that as a path forward. But move forward with National Emergencies Act reform and then take the time to get IEPA right.
Senator Ossoff, you're recognized for your questions.
Thank you, Mr. Chairman. And this conversation has focused, I think, on what's practical legislatively. I want to ask each of you what's most pressing. So putting aside the question of what can practically be moved through this Congress, which, for each of you, please, beginning with you, Ms. Gotin, which single statutory reform, one, in brief, do you believe is most pressing with respect to presidential emergency authorities?
I think it is the congressional approval requirement for national emergency declarations. And the reason that I think that is not only because it can be done immediately, but it has the biggest bang for the buck because it significantly curtails the potential for abuse of more than 130 different emergency powers, and it does so by restoring the balance of power between the president and Congress in a way that's just good constitutional hygiene. So I agree with something Mr. Healey said earlier, which is that Congress should also examine the individual tools in the toolbox. Some of these are powers that arguably no president should ever have, such as suspending the prohibition on government testing of chemical and biological agents on unwitting human subjects. However, I think for the biggest bang for your buck, start with National Emergencies Act reform with a congressional approval requirement.
Thank you. Mr. Thullum?
Yeah, second that. Think of this as a meta law, and probably the ideal situation would be to reform and address and maybe repeal all of those emergency statutes. I just don't know how you'd go about triaging that. I think the single most important element, though, of reform is time limiting. An emergency is impossible to define in all its characteristics, but by definition, it should be time limited. Otherwise, it's not an emergency. So there should be some mechanism that by default ends emergency declarations unless Congress says, you know what, you're right, this is a continued problem, we're going to take a stand and we're going to extend it.
Mr. Healey?
Hate to be boring here, but I agree with my co-panelists. Despite what I said about addressing substantive powers, I do think that a sunsetting emergency declarations and requiring affirmative approval by Congress to extend them further is the most valuable reform that can be made if you have to pick one. And I think in particular it's valuable because, as I said a moment ago, you wouldn't have predicted recent presidents seizing on these two statutes, the Military Construction Codification Act and the HEROES Act, but we've seen that when presidential restraint in these areas starts to erode, there's a lot of creative lawyering in statutes that you might not have thought were bottomless wells of unilateral power can be turned to that purpose. And by sunsetting declarations and requiring affirmative approval, I think that tackles a large part of that problem.
Mr. Healey, and then we'll go back down the line this way. Which emergency power do you believe is most broadly or urgently threatening to civil liberties and due process rights?
Well, the provisions of the 1934 Communications Act that were mentioned earlier, I think are pretty sweeping and staggering. Not something that a president needs, even in a genuine national emergency. I think the potential application of IEPA to U.S. citizens to directly target them and the lack of meaningful due process in that area is also a concern. But again, I think looking down the list of those 130 powers, we should expect that there's any number of them that will be put to uses that we couldn't predict in advance.
Thank you. Mr. Thullum, same question. The single power you believe most threatening to civil liberties and due process?
I second the 34 Communications law, especially in the context of creative lawyering and what communications means today versus what was envisioned in that law.
Thank you. Ms. Gotin?
I agree. The Communications Act and IEPA are probably the ones of most concern. I'm going to flag a third one since those two were already discussed, and that is a provision that allows the administrator of the Transportation Security Administration during a national emergency to exercise such powers over transportation as the Secretary of Homeland Security shall prescribe, which appears to be a completely open-ended delegation of authority to the Secretary of Homeland Security to control domestic transportation with no limits or specifications. And of course, the ability to move around freely is critical to many of the other individual liberties that we all enjoy. So that
Can I
one
just
worries
tag
me.
one quick thing? I think that the power you should be worried about is the one you haven't thought about. It's the creative, going through the archives and finding some obscure provision that no one's thought about in years, and imagining an administration 10, 15, 20 years from now pulling it out of the archives and saying, I think this authorizes a pretty unprecedented exercise of power.
Ms. Gotin, how could a administration use emergency powers to disrupt the peaceful transfer of power from one elected executive to the next?
I wrote about this a little bit in an article that I published in The Atlantic in 2019. To be honest, I'm reluctant to go into too much detail about how emergency powers could be abused in this way.
I think that's, with respect, what you're here to testify on.
Right. I think we need to be very cautious in having these discussions. One emergency power that actually falls outside the National Emergencies Act framework that I'm worried about is the Insurrection Act. The Insurrection Act is a law that allows the president to deploy federal military troops to quell civil unrest or to execute the law in a crisis. And there's a lot more to say about it, but it gives the president extremely broad and judicially unreviewable discretion to deploy troops in ways that could certainly be abused, and that could be abused in ways that could throw a wrench into the works in terms of a peaceful transfer of power.
Brief comment on the Insurrection Act from each of you. I'm over time now. If you could sort of, Mr. Healey, I'd like your perspective.
Yeah, I think it falls into the category of powers that can certainly be abused. I mean, it hasn't been invoked since the LA riots, I believe, in '92. But if you look at the discretion the president has under that act, it's certainly something that would be prudent to tighten up.
Thank you all. Thank you, Mr. Chairman.
Thank you. Senator Hessen, you're recognized for your questions.
Well, thank you, Mr. Chairman and Ranking Member Paul, for holding this hearing, and to all of our witnesses, thanks for being here and for sharing your thoughts about how Congress can reform presidential emergency powers and strengthen congressional oversight of those powers. I want to shift the conversation just a little bit because of my role as chair of this committee's subcommittee on spending oversight, which is tasked with combating waste, fraud, and abuse in federal programs. I am concerned that bad actors take advantage of national emergencies to access funding intended for victims, such as we saw during the COVID-19 pandemic. So, Ms. Gotin, does current law adequately safeguard taxpayer dollars from waste, fraud, and abuse during presidentially declared emergencies? And what additional safeguards or oversight mechanisms do we need to strengthen protections against waste, fraud, and abuse during a national emergency?
That's a great question, and it goes to this question of congressional oversight. Congress should be able to oversee exactly how emergency powers are being used, including how funds are being spent. There is a requirement in the National Emergencies Act that presidents report to Congress every 6 months on the expenditures incurred as a direct or directly attributable to the exercise of emergency powers. Now, that requirement is not sufficiently detailed. It should require more of a breakdown. It should also require the president to specify the particular actions that were taken. But even this minimal requirement of reporting expenditures has been honored in the breach. When it comes to declarations that rely solely or primarily on IEPA, the responsibility for reporting has been delegated to the Secretary of Treasury, and the Secretary has in fact submitted those reports. You can find the notations of the submission in the congressional record. When it comes to all other emergency declarations, it appears that the executive branch has not been submitting these expenditure reports for more than 20 years. There are no notices in the congressional records. Congressional committees that should have received these reports have been unable to find them. Reporters who have submitted FOIA requests have been told that there are no responsive documents. By all appearances, the executive branch has simply stopped complying more than 20 years ago with a statutory reporting requirement, and that's indefensible. And it prevents Congress from doing the kind of oversight you're talking about.
So does the reform legislation that you all have been talking about address this? I mean, if the executive branch is just not doing it, do we just need to keep that portion of the Emergency Act as is and just figure out how to enforce?
The reform legislation does include enhanced reporting requirements, but it doesn't directly take on this issue of noncompliance. And I think Congress might need to start thinking about actions that it can take. I would remind all of you that Congress has the power of the purse. Congress can provide, and it has done this in the past, that certain amounts appropriated in funding bills will be withheld or reduced by 10%, 25% if required reports are not submitted.
Well, thank you for that. I now do want to go back to the broader topic, because a president's ability to declare a national emergency can play an important role in accelerating the delivery of resources to areas that need them. So there are times when it's the really appropriate thing to do, and we've all acknowledged that here. But Congress obviously needs to provide oversight and a check on these emergency powers. Under current law, national emergency declarations can continue on for long periods of time. Ms. Gotin, how many national emergencies remain open for long periods of time, and how long are emergency declarations typically held open?
Right now, there are 43 emergency declarations in effect. Most have been in effect for longer than a decade. 43 is a majority of the emergency declarations that have been declared since the National Emergencies Act was passed. So there have been 79 emergency declarations. 43 of them, most of them, are still in place. The longest running emergency declaration dates back to the Iran hostage crisis in 1979. And we have calculated that the average period of time for these emergency declarations is approximately 10 years.
So you all have talked about this some, but I'm just going to give you an opportunity. What does it mean for the scope of executive authority if national emergencies can be left open for long periods of time? And what changes, again, you've talked about some of it, but we'll just go down the panel. I'd like you all just, what changes would you recommend? But start with just what does it mean for the scope of executive authority?
So what has happened is that this country is being governed in a state of perpetual emergency. We have these semi-permanent emergencies that displace the normal operation of law, and that is the status quo. That is extremely unhealthy for a democracy. More concretely, anytime the president declares a national emergency, he or she has access to almost all of the 130 powers, 137 powers actually, most of which don't include any particular requirement that anything other than an emergency declaration be in place. So even if the National Emergency Declaration relates to one specific area of governance, dozens of emergency powers in multiple other areas of governance become available to the president. And so the temptation is to leave these declarations in place indefinitely because it gives the president access to such a deep well of powers.
Mr. Thullum.
I mean, so think of it this way, in all those other emergency power statutes, right, those are supposed to be delegations of authority in particular circumstances, time, and place.
Right.
And there is a robust argument about what is the scope of delegable authorities and so on. We'll kind of put that aside. But the point is, Congress meant for those to only exist in certain circumstances. I would say at a very minimum, time-limited circumstances. And what they've effectively become is now just writ large authorities that have just been wholesale granted to the executive. That's what you get. You get Congress trying to be judicious in saying, okay, we acknowledge that sometimes things happen, you can't foresee, and it would take too long, and in execution of the law, the president should be able to do this thing. But now that's just in all time, in all places, in all circumstances. So it really is it self-defeats the Congress's Article 1 prerogative to decide when and where the executive is supposed to have certain authorities.
And just briefly, if I could, Mr. Chair, for Mr. Healey.
Sure. You know, if you look down the list of 43 emergencies, you know, you will see very few that are considered genuine emergencies. Titles like referring to the situation in Burundi or something like that. And so I think there is a problem with longstanding declarations dating back to 1979, even where they're relatively uncontroversial, in the sense that you know, we've defined emergency down, and as someone put it, we were sort of cheapening the currency of national emergency. The national emergency should be something, you know, akin to a war, in unforeseen circumstances, a pandemic, an asteroid strike, and the effect of a long list of longstanding national emergency declarations, most of which do not seem to be genuine emergencies, I think undermines the seriousness of the concept.
Thank you. Thank you, Mr. Chair.
Thank you. Ms. Gotin, your research shows that presidents have only recently begun to really push the bounds of the emergency powers in their policy priorities. So my question for you is, why do you think that's the case? Why are we really now seeing this recently where we didn't see it before? And the other two witnesses, feel free to chime in as well. But Ms. Gotin.
To be clear, there have been abuses of emergency powers in the past, but the most egregious abuses that we've seen in the last 100 years in this country have been based on claims of inherent constitutional authority, not statutory emergency powers. So that was the case for the internment of Japanese Americans during World War II, for example. That was also the case with the torture of detainees after 9/11. When it comes to the powers available under the National Emergencies Act, there has been remarkably little abuse or misuse, other than IEPA, which really has to be considered separately for some of the reasons that we've talked about. When presidents have declared national emergencies, it's been few and far between, and it has generally been in response to a sudden, unexpected crisis that required immediate action. And the reason for this, and this is really more of a description than an explanation, I think, has been a norm of self-restraint on the part of presidents who have access to these powers. And the problem with that is that once these norms are shattered, they are extremely difficult to put back together. President Trump opened the door to abusing statutory emergency powers when he declared a national emergency to secure funding for the border wall after Congress had refused to provide that funding. President Biden nudged the door open a little bit more when he relied on emergency powers to forgive student loan debt, again, after Congress had considered legislation to forgive debt and had not passed that legislation. So, you know, I think we have had a norm that has protected us, and now that that norm has been set aside, I'm concerned that we could see more of these misuses of emergency powers in the future.
I don't think I can draw a conclusion about the long sweep of history and the increased use of emergency, but I'll say that in our time working on this issue at the committee, it was different emergencies that motivated both Democrats and Republicans on the committee. I think if I could, I'm in the weird position of speaking for people who are sitting on this very dais, which I think constitutes hearsay, but some of the Democrats on the committee were motivated, were interested in this topic by that border wall emergency, right? It crystallized this notion of creative uses of emergency power that seemed beyond what was delegated by Congress. Later on, COVID, the student loan emergencies drew interest, especially from more the Republican side of the committee or in Congress. I think the point is, if you create a policy-neutral mechanism that's kind of a meta law, you don't have to, well, I don't say you don't have to worry. I think what you do is you don't address a specific emergency. You're addressing the whole notion of emergency powers. And that's one thing that I was proud to have been able to work on, even though different members of the committee were kind of drawn to the legislation for different reasons or in response to different reasons, it arrived at the same answer. And I would note, during that time, nobody on the committee that I spoke to raised an objection with the thrust of the legislation. There were disagreements about whether IEPA should be included and so on, but nobody disagreed that this was something that wasn't worthy of the committee's time.
Senator Rosen, you're recognized for your questions.
Well, thank you, Chair Peters, Ranking Member Paul. This is a really important hearing, and I appreciate the witnesses being here today. And of course, the National Emergencies Act, NEA, provides the President with 135 statutory powers when they declare a national emergency. The powers cover a wide variety of critical areas. We've all talked about them, ranging communications, transportation, public health, military power, so on. And while these powers, of course, can be helpful in the face of true emergencies, as we've heard in our testimony today and your testimony today, they're also subject to potential abuse. It's therefore critical that we address the potentials for reform and we prioritize executive accountability and preventing abuse of power. So, Ms. Gotin, during your testimony in the House last year, you mentioned that there's no existing requirements that powers invoked by the NEA have to actually relate to the emergency declared. They do not have to actually relate to the emergency declared. So while considering potential reform options for the NEA, how should Congress ensure that presidents don't abuse unrelated powers that could become available during emergency? I found this pretty interesting.
The congressional approval requirement after a period of 30 days serves as a kind of meta check on all forms of abuse, including using certain powers that don't even relate to the nature of the emergency, a perpetual emergency in order to gain access to other powers, as it were. But there are also versions of National Emergencies Act reform that explicitly require that the powers invoked must relate to the nature of and be used only to address the specific emergency that serves as the basis for the declaration. So that's another way to go about it more directly.
Thank you. I appreciate that. And when we think about whether something's germane and how we have accountability, we think about reporting requirements as well. And so executive accountability for the use of these emergency powers, it must be a priority, but current law and practices make oversight and accountability nearly impossible. And as you were just saying earlier, although there are existing reporting requirements for the NEA reports, they can be difficult to obtain and if they're available at all. And so these reports are essential to having congressional oversight into NEA declarations and terminations. So, Mr. Thullum, building on what Ms. Gotin was saying, based on your experience in the executive branch, how can Congress strengthen the NEA reporting requirements to ensure that powers are being used appropriately and transparently? We need to see these things.
I mean, absolutely. That's absolutely correct. I mean, as Liza mentioned, in some of the reforms talking about, there is a more explicit requirement for the declaration to be tied to the powers being invoked. And also reporting on those powers and how they're being used, and presumably how funds may be invoked or be changed in response to that. I think it's important to keep in mind also, it's not that a lot of damage can't be done in 30 days, if that were the default time limit, but it's not an unending amount of time if you add an automatic sunset. So it doesn't devalue the Congress's role to do that oversight, which they're entitled to, but it makes it much less of a concern of years and years go by, and the administrator of that office that was in charge has now left, and the new people come in and say, well, I'll get back to you when I get caught up, and that sort of, you know, kind of hand waving that happens. It makes the issue that's being invoked, the emergency that's being responded to, salient and momentary in the long scheme of things, which also forces Congress to have to make a say, right? To take a stand, and that forces all of Congress to say, wait, what do we know about this? Or what do we need to know about it? As opposed to a member of a committee that's looking at an emergency from 10 years ago and is trying to catch up. You know that
That's right.
getting everyone kind of in the same room metaphorically makes it much easier to force the executive branch. It makes it harder for them to ignore.
Right. Well, that builds exactly on my next question, is reevaluating existing emergencies. And of course, emergencies are happening every day. Just watch the Weather Channel and you see some tragic weather events happening. But as you all have noted here today, there are currently over 40 ongoing national emergencies still in effect, dating back to the 1970s. Many of these emergencies remain necessary for U.S. national security. I get that, but as I understand it, there's little in current law forcing presidents to reevaluate emergencies that have been on the books for decades. Something from the 1970s perhaps should be reevaluated. So to each of the witnesses, in addition to reasserting congressional oversight of the use of NEA, what do you think we can really do to incentivize future administrations to assess the value of existing emergencies? And what can we do about, if they've gone on this long, maybe there's some other legislation we need if it's in our national security interest, for example. Let's begin with Ms. Gotin, and then we'll just go down the line. What do
Sure.
you think?
So under all of the National Emergencies Act reform proposals that are currently pending before Congress, not only would emergency declarations terminate after 30 days unless approved by Congress, but every year after that, if the president wanted to renew the emergency for another year, he would again have to get congressional approval using expedited procedures. That does two things. First of all, it enables Congress to act as a check. That's the most important thing. But it also forces the president to examine the powers that the president has been using, to examine the success of those powers or the failure of those powers, to examine whether the conditions leading to the original emergency declaration aren't still in place, whether they've changed. To do that analysis to determine whether continuation of emergency powers is really necessary, or whether what's needed instead, or whether the emergency declaration can simply be withdrawn, or whether what's needed is new legislation, a new permanent authority to deal with a circumstance that may have become a new normal.
That's right.
So I think that particular reform is not only a check that Congress can apply, it is also, it also forces some discipline on the part of the executive branch.
Thank you. Mr. Thullum.
I think what you see over time has been a lot of ceding of foreign policy to the executive branch, and I think generally most folks think that is kind of a purview, an area that the president has. But you know, for instance, our posture towards Iran, this is of national interest, and it probably shouldn't be subject to an ongoing emergency, quote, emergency policy. This is a thing, I guess I don't have a good answer of how to force the president to table, any president, but that should be a matter for congressional deliberation and consideration. And if it should be a permanent policy, but for a change in regime, for instance, I'm not a foreign policy person, that should be a deliberation that happens between the executive branch. We can't have a 40-year emergency. That's just not how, and so if that should be a permanent policy, then we've gone from emergency response to just good old-fashioned policymaking. That's supposed to be an Article I prerogative. So I guess I'm kind of hand-waving a little bit. I don't know how to force that discussion, but Congress should be asserting that and saying, we may even agree with you, Mr. President, but we need to have a say, and we need to go through the process to approve it and make it explicit.
Yeah, thank you. And Mr. Healey.
Yeah, I think what you tend to see is the emergency, with the exception of the COVID-19 emergency that was actually repealed legislatively. You have most of the time it's the president proposes and the president disposes and maybe gets rid of some long-standing emergency declarations when international conditions have changed. Again, I think that has the effect of devaluing the currency and seriousness of emergency. If you have a list of 43 emergencies and a normal person would only recognize 2 or 3 of them as emergencies, I think that's a problem. And I think at some stage, whether you know, it should be done as part of the same package or not, but at some stage, since the bulk of these are IEPA-related emergencies, I do think as putting him under time limits and an approval requirement would force some scrutiny from the legislative branch and the executive branch as well about whether to reapprove some longstanding emergencies.
Thank you. Appreciate it. Thank you, Mr. Chair.
Ranking Member Paul, recognized for your questions.
I'd like to have a stab at answering your question about, when did the emergencies arise? And I would probably put it together, when did the emergence of a strong central executive arise? And at some point all the way back to the Civil War, many would say the 20th century, many would say the Great Depression, but without question, the executive has grown in power and Congress has diminished in power over the last 100 years. Part of that's emergency power and part of that's many other things. Most of the questions I get about a regulation of this business or that business, we never voted on. And this has been a big question now between the Supreme Court on Chevron deference, whether or not we write the regulations or we just give broad frameworks and regulatory agencies write all the regulations. But I'd say it's a long-term trend and emergency powers is part of that. Now, the argument has been made that, and this is a common argument around here, and I disagree with it, that, well, the only thing that's popular is reforming just the NEA, leave IEPA out, leave everything else out because this is popular, we can get it done. It's possible. There are other really important things, maybe more important, but they just can't pass. I would argue that sometimes something is so popular that other issues that are related can be discussed and may well be accepted. All three of you said that the internet kill switch is probably the most important and possibly abused power, hasn't been used, but that could be so devastating that someone could become dictator, basically. You control all the communications in the country, you could become dictator in a day, in a moment, in one executive order. And we have that in our bill for reform. We have it in there. You all seem to agree. I think there's a lot of agreement up here on getting rid of the internet kill switch. So why sell ourselves short? Let's don't just say, oh, we're only going to do this one thing. Yes, the most important thing is changing from where we have to override a veto to kill an emergency. We have to have a 2/3 vote. That is way too high a burden. We need to get it back to that it expires and that then we can then vote. But let's don't sell ourselves short. Let's have a real robust discussion. Let's just don't say, oh, well, I'm against the internet kill switch, but it just isn't the time. And so I'm going to vote no because we'll do it some other time. Some other time never comes. So now is the time. And the general category, they all fit, are emergencies. I would argue, and I agree with Ms. Gotin, the Insurrection Act is 1,000 times more potent and has the potential for turning the place into military rule overnight, that it's more important than any of the 4 emergencies that we'd fix with changing this. I'm for fixing it so all these emergencies expire and that we have to reaffirm them. That's a great reform. But the Insurrection Act is probably more deadly and more powerful than anything we're discussing today. So we actually have that in my reform bill. I know I'm not going to get everything I want, but let's talk about it now. We're talking about emergencies. My Insurrection Act reform would simply say, President can't send the military anywhere without the approval of Congress. I'm really not for sending the military domestically. I really don't think the military should ever be used domestically. If we're talking about handing out water or preventing a foreign invasion in a time of a hurricane, maybe. But our soldiers are great, but they're not trained to obey the Fourth Amendment. Our police are, and even that's imperfect, but our police know about the Fourth Amendment. They know they have to get warrants. Armies don't get warrants. It is a potential for a huge disaster. So we should have the debate over the Insurrection Act. Maybe we can do it in a separate hearing, in a separate bill, but we're going to at least bring it up on this. And if I get a chance, that's one thing that I will want us to vote on. Take a stand. Do you think the president should be allowed to send the military into our cities? I think no. The approval of the governor is not enough. I can imagine a governor that makes a bad decision too. And then it's 2 people have made the decision to have military rule in an area. And then if it doesn't expire, it could go on forever. So the Insurrection Act should also expire too, so Congress would have to, I think from the very outset, troops shouldn't go in without our approval. But even if that happens, it should expire in a short period of time. The problem with giving 30 days for the Insurrection Act and patterning out an emergency is 30 days is a long time to have troops in your cities. So I would say is none. I would not allow troops to go in at all without an affirmative vote at that time of Congress to allow troops to go in. And I would almost assuredly vote no on that for anybody. We have police. The police are very well armed. The police, deal with riots in our cities. And that's the way we should deal with it, because it is a tough job to figure out due process for people and figure out the difference between protest and riot and between violence and how we deal with it. And so I would just argue, let's be more open-minded to talking about the Insurrection Act. And I would say that the internet kill switch, I think we can get some bipartisan support for just getting rid of that. Most people are horrified. You tell any of your constituents that the president could shut it down, and it works both ways. The left may go home and say, oh, Trump's going to do this, and the right goes home and says Biden's going to do this. I don't want anybody to do this, and no one should have ever been given the power to shut down all transmissions. Now, I have heard from some people who say, oh, well, what about sending out emergency broadcast or something? That's not what this is. And I don't think we need to have this power to send out emergency broadcasts that there's a hurricane coming or something. But anyway, I would just argue for being more inclusive and not limiting ourselves to only one thing, even if the others can't pass. I may not get my way on IEPA, but if we only do 4 emergencies and we leave all the other IEPA out there, I see no reason why I'm skeptical that sanctions work. But those who like sanctions, vote on it. They're stronger if you actually vote on it. Let them expire in 6 months. President does them, let them expire. We don't have to do each one, bulk them into the emergencies, do all Russias together, all Chinas together. But then if you think sanctions work, they're stronger, having been voted on by Congress. So I'm open response to anybody who wants to argue with me that we should limit this to only one thing.
I would never. But
Politica.
But I would note, we speak of the 2019 reform that we worked on this committee, that you both voted on and participated in. It's kind of shorthanded. We speak about it as having carved out IEPA, and I think in one sense that's true, but it actually did pull in and removed the authority, not just as a sunset, but removed the authority pursuant to IEPA for the president to unilaterally impose tariffs and rate quotas. So that's a small piece. That's not everything you're talking about.
Senator Carper's piece was included in that.
I
think he has an individual bill on that.
I believe it was Senator Portman and yeah, maybe
Carper,
Senator
yeah.
Carper. And so it was offered as an amendment, and then I think was wrapped into the base tax. Now that's not all of IEPA. That does not address what you're talking about. But I think you can. It showed that you can at least pull in some of the authorities that you're concerned about. And I don't want to. I just don't want my testimony here today to be thought of as just don't touch IEPA, just go forward. I'm saying you can. I just want to caution, just based on my experience here as a witness, to say that's what I experienced. And I am almost certain that if we had tried not to carve out any part of IEPA, the bill would have languished. Now, to me, it didn't pass anyway.
Just realize the frustration on our side. I get this all the time. I'll have people on the floor, and we'll get to an amendment finally on the floor and say, well, we've agreed to have no amendments. I'm going to vote against. Yours is a perfectly good amendment, young man, and we would, in any normal time, we'd be for you, but this time we're against you because we made a deal. No amendment. You know what I mean? So we just need to be more open-minded and not limit ourselves. I won't get everything I want. I won't get all of these things reformed, but let's don't preemptively say we can't. So I appreciate your comments. Anybody else?
Yeah, I want to be very clear. I am not saying, let's do this one thing because it's here, we can get it done and forget about the rest. The Brennan Center is actively advocating for reform of the Insurrection Act. We have a detailed legislative reform proposal. We are actively advocating for reform of IEPA. We have a detailed legislative reform proposal. We're looking at the Communications Act. I'm not entirely sure that full repeal is the right solution there. It might be. I think it's going to be important to look at whether some very dramatically narrowed version of that power might be needed in cases of, say, cybersecurity attacks or something like that. And again, this is something we're looking into right now. We might ultimately support repeal. But anyway, these are issues that I consider to be incredibly important, top priorities. But I do think that on the substance of what needs to be done with these authorities, they have to be dealt with differently. and separately. Now, I suppose you could say, well, let's just write the reforms for each of those and tack it on to National Emergencies Act reform legislation, but that work has to be done, and it hasn't been done yet. And the work of sort of gathering the coalition, the consensus, the markup that was held on National Emergencies Act reform, the tire kicking that's happened over these past few years, I don't want to hold National Emergencies Act reform hostage to any of these other reforms, which I think are absolutely and
I don't think it will be, but I would suggest trying to come to a conclusion on the internet kill switch. This is a chance. It might be 5 years, it might be 10 years, it might be never. When you have a chance, go for it. And all it takes is, you've all said it was the most important power you would actually remove, so come to a conclusion on it. If you want to carve out for putting out PSAs on there's a hurricane coming, I don't think you need that. I think that's probably done through other legislation. It's actually mostly voluntary. Believe it or not, people will do things voluntarily in a crisis. Most people, plus most people don't even get it from government anymore. Your warnings are really mostly outside of government for emergencies. But anyway, come to a conclusion on this because, if we want to bring this up in a month, we just don't want your center, which is on our side on this, to be against including killing the internet, the internet kill switch. And so just be open-minded. If you can come to a conclusion, try to come to a conclusion. On the Insurrection Act, it's unlikely to be, but I will, I'm a believer in having votes on stuff. I will have a vote on the Insurrection Act. And I think it is different. It won't be the same reform as the NEA. It has to be more strict than the NEA because you're talking about putting troops in our cities. And so I think troops in our cities should be a vote of Congress, no matter how good the cause is. There's so many other ways to deal with emergencies beyond having the Army in our cities.
If I could say one last quick thing. You refer to the 4 emergency declarations. I think it's actually 3 right now. One was terminated. So there's 3 emergency declarations that do not relate to IEPA that are currently in place. I just want to be clear. Those 3 emergency declarations are not the ones I'm worried about. It's the ones that haven't been declared yet. So I don't think we should downplay the significance of passing National Emergencies Act reform, even if it doesn't address IEPA, because there are untold declarations that could happen in the future. As Mr. Thullum says, it's the powers you haven't thought about yet. That is what we are preventing through this legislation.
Mr. Healey, can you close this out?
Yeah, I don't think anyone wants my advice on the politics of it, and it's not worth much, frankly. But I do see the merit in taking a broad approach to this and to deal with at least a few of the biggest substantive concerns. And again, discounting my political advice for what it's worth. That's not what I'm here to testify on. But I think we all agreed that the 1934 Communications Act provisions are a huge concern. And I think at this moment, when there is bipartisan interest in emergency power reforms, that some of the more dangerous, it's about what it's as Satya said, the ones we're not thinking about are important, but some of the ones that you would pick out, if there's an opportunity to tackle them and reform those powers, are also worth addressing.
One final question for you, Mr. Thullum, and others can have their opinion as well. The reform proposals that are right now before us allow Congress to approve an emergency for a set period of time. And at the end of that period, then Congress can renew the emergency with another vote. So my question is, what do you think is an appropriate amount of time for a national emergency to last before it needs to be renewed by Congress? And if anyone else would like to.
This was subject to some deliberation, also in the committee, when we were considering these. This is a prudential question, and this is exactly the kind of thing that Congress is supposed to figure out. On some level, look, it's arbitrary because you are setting a time limit that is not correlated to the actual emergency in that time. But I think anything more than 60 days is. You're going to a quarter of a year, 90 days, that's not an emergency. And again, I guess the point is less about what is the appropriate specific time limit and more about Congress should have to weigh in and continue to weigh in if it's extended, and that's a policymaking muscle that Congress has not exercised in a long time. And so I think somewhere between 30 and 60 days is appropriate, but the specifics we have to leave to you.
Other thoughts?
I think 30 days, which is the amount of time in most of these reform proposals, is a sensible amount of time. It gives the president enough time to implement at least the first wave of whatever actions the president's going to take in response to the emergency. It gives Congress time to see how the president is addressing the emergency, how the emergency is unfolding. And then Congress can weigh in. If Congress extends the emergency, then it would go back to the usual yearly renewal. But instead of the president being the one to renew the declaration unilaterally, Congress would again have to approve it. Now, some versions of National Emergencies Act reform also include a 5-year cap on the total amount of time that an emergency declaration could be periodically renewed by Congress. And the idea behind that is to prevent this phenomenon of permanent emergencies. 5 years into an emergency, it's not an emergency, it's a new normal. And arguably, it should be addressed through permanent authorities. If existing non-emergency authorities aren't sufficient, then Congress should be passing new ones. So that's another feature of some of these reform proposals that's worth consideration.
Well, very, very good. I'd like to thank Ranking Member Paul for holding this hearing with me here today. And I'd also like to thank each of our witnesses for joining us and sharing your insights. I think it was a very fruitful discussion. Certainly expanding congressional oversight over national emergencies is absolutely critical to ensuring a healthy balance of powers as envisioned by our country's founders. And as we heard today, presidents have very broad authorities that could be misused. At the same time, the federal government also must be able to rapidly and effectively respond to various types of emergencies. But as I believe our 3 witnesses explained today, there are some common sense reforms that would strengthen Congress's role in exercising oversight of these emergency powers. And I certainly look forward to working with Ranking Member Paul and other members of the committee to advance legislation that incorporates the bipartisan reforms that we have heard about today. And I'd say nonpartisan reforms is probably a better way to characterize it. And we will be working diligently to make that happen in the coming months. The record for this hearing will remain open for 15 days until 5 p.m. on June 6th of 2024 for the submission of statements and questions for the record. This hearing is now adjourned.